So the question for today's video is hypothetical because the real question as to whether Lindsey Halligan was validly appointed as interim U.S. Attorney for the Eastern District of Virginia, in my view, has to be resolved in the affirmative. Now, I talked about that in my previous video, so let's put aside the issue of her appointment. The hypothetical is: now, would the indictments of James Comey and Letitia James be valid, even if presented to a grand jury by someone without the authority to act as an attorney for the government? Now, that's the hypothetical that was posed by the government in its brief. The government is appealing the dismissals of both indictments by a judge last year. The appeal is at the Fourth Circuit and probably will go on to the U.S. Supreme Court. Now, the district judge who dismissed both indictments is Cameron Curry. She held that U.S. AG Pam Bondi's appointment of Lindsey Halligan as interim U.S. attorney was an error of constitutional proportions and that the indictments obtained by Lindsey Halligan must be dismissed as a result. The judge got it wrong. Now, if a mistake was made in appointing the prosecutor, now why would that make James Comey and Letitia James the beneficiaries of that error? Now, we understand from the criminal law and criminal procedure that defendants only get their cases dismissed for prosecutorial misconduct if the misconduct undermines due process and cannot be remedied. For example, a prosecutor who always strikes jurors of a certain race during jury selection. Now, that type of misconduct creates a structural error in the trial in which the defendant cannot get a fair trial. So, dismissal would be justified. Or maybe the prosecutor tampered with witnesses and now their testimony is irreversibly tainted. The misconduct creates a structural error in the trial that cannot be remedied except by dismissing the indictment. Now, what we have with the appointment of Lindsey Halligan is very different. The defendants say she had the wrong title, that she wasn't the interim U.S. attorney. But being the interim U.S. attorney wasn't a requirement for her to lawfully present a case to the grand jury. Now, the government's appeal brief cites a great example. Many courts have declined to dismiss indictments in which the prosecutors had been suspended from the practice of law when they appeared before the grand jury. And that's not surprising. Such misconduct is unrelated to the merits of the defendant's cases. Now, it would be different if, for example, a suspended prosecutor had tampered with witnesses or had struck jurors of a certain race 80% of the time during jury selection while being suspended. So that's the distinction. For example, if the prosecutor is a man who beats his wife, let's say, it's misconduct, but it doesn't impact the fairness of the defendant's trials. James Comey and Letitia James. Now, they aren't the victims of his misconduct, in other words, so why would they get their indictments dismissed? Further illustration. What if James Comey and Letitia James were both murderers? Okay, would it be fair to dismiss their indictments just because their prosecutor is unmasked as a domestic abuser? Now, it wouldn't be fair. Now, that's why legal reasoning says their indictments should not have been dismissed. So, why did Judge Cameron Curry dismiss their indictments? Now, as I mentioned in my previous video, she discarded many rules of statutory construction. Those rules are guardrails, and she ignored them. She also seemed to be conflating two different statutes. Now, the judge supposedly was analyzing Title 28 of the U.S. Code, Section 546, which governs the appointment of interim U.S. attorneys. But there's a completely different statute called the Federal Vacancies Reform Act, which governs the appointment of quote-unquote acting officers of the United States. Now, the judge liked that one better. So she leaned heavily on a specific provision in that statute that's missing from the statute she was supposed to be analyzing. Now, the statutes both deal with appointments after a sudden vacancy in federal government offices, but they're different statutes. Now, the Federal Vacancies Reform Act discusses how the executive branch could temporarily staff vacancies that require Senate confirmation. The act says that with regard to acting officers who are found to have a defect in their appointments, let's say an acting U.S. Attorney General, if it turns out the appointment is defective, the acting U.S. AG's actions are void and cannot be ratified. Now, in the case of an AG, that makes sense because the Attorney General reports only to the President, but the President cannot ratify all actions of the AG. Now, for example, if the acting AG conducts a grand jury proceeding and later the appointment of the acting AG turns out to be defective, in that case, the indictment probably would have to be dismissed because no one can ratify that type of action by the head of the DOJ. Now, not surprisingly, that provision making the acting official's actions void is absent from the Interim U.S. Attorney Appointment Statute, Title 28 U.S. Code, Section 546, because the actions of an interim U.S. attorney can be ratified by the AG. Now, U.S. attorneys report to the AG, and the AG delegates her authority to conduct grand jury proceedings and all types of proceedings to U.S. attorneys and to other government attorneys. So, with the two different statutes, let's keep in mind that statutes are legislative creations put in writing by the Congress after excruciating drafting and debate. Now, Judge Cameron Curry can't just reference a provision in one statute and read it into a different statute. Now, we could even say that in some ways, the Federal Vacancies Reform Act, in the context of an acting official whose appointment turns out to be unlawful, does away with the centuries-old doctrine called the de facto officer doctrine, which says that the actions of a person with a colorable claim to an official title are valid. Okay, the actions are valid even if it turns out later that the appointment was defective. So the doctrine has been used for centuries and was developed through the English common law. Now, it permits governments to operate without being stymied by constant challenges to the authority of the government's officers. Now, in the context of the DOJ, the Federal Vacancies Reform Act allows the president to appoint acting attorneys general, for example, to fill the role temporarily for up to 210 days. Again, it's a different statute than Title 28 U.S. Code Section 546, which governs interim U.S. attorney appointments. But Judge Cameron Curry jumbled them together in her ruling. That's what happened. Now, one of the federal courts of appeal has even recognized that an interim U.S. attorney is more powerful than an acting U.S. attorney. Now, it was the Ninth Circuit, which covers 9 states in the western U.S., including California and 2 territories. Now, the Ninth Circuit suggested that an acting U.S. attorney is lesser than an interim U.S. attorney because the acting U.S. attorney's actions can be voided if it turns out later there was a defect in the appointment. So, in summary, 2 different statutes. The judge, Cameron Curry, morphed them together in her ruling and got it so wrong. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.